decades now, employers have had anti-harassment policies in place with regular training programs for managers and employees. With the emergence of the Me Too movement, however, we see now that many of those policies and training have been ineffective. The movement brought to light the degree to which these issues have been underreported in the past. But in the era of Me Too, the fact that victims fail to report harassment to their employer does not mean that they remain silent. Instead, they may circulate lists of colleagues to avoid, write explosive blogs, or go straight to social media with their stories. In times like these, organizations cannot afford to not know about harassment in their workplaces. It is too costly a risk to take. The average out-of-court settlement in a sexual harassment matter ranges from $75,000 to $125,000. And the cost to defend a sexual harassment claim through trial can reach upwards of $250,000. But more than dollars and cents are at risk. The failure to prevent or promptly respond to a Me Too crisis can also cause significant damage to an organization's brand and public interest. Today, we will walk through what organizations should consider to try to prevent a Me Too crisis and what steps to take to manage a crisis if one occurs. I'm going to start by giving you some background on the landscape of sexual harassment, reporting and response, both before and after the Me Too movement. Then we will discuss some new considerations organizations should make in light of Me Too. Finally, we will walk through the basics of crisis management and outline proactive steps that organizations can take to reduce the risk of a crisis in the workplace before it starts. It goes without saying that the Me Too movement has proved to be a watershed moment for how we view and treat sexual harassment in the workplace. In order to understand why the Me Too movement is a new paradigm for employers, it's worth spending a few minutes discussing the sexual harassment landscape before the movement. In the pre-Me Too era, employers could rely on legal or technical ways to fend off claims of sexual harassment. For example, an organization could assert that the victim failed to complain about conduct to allow the organization to conduct an investigation and remedy the situation, or two, that the conduct complained about was not, quote, severe and pervasive, close quote, or that the claim was asserted too late and barred by the statute of limitations. And when an incident of harassment was investigated and substantiated, an organization typically entered into a settlement agreement with the complainant that included a non-disclosure and confidentiality provision. Thereafter, the complainant was typically reassigned to a different role or department in the organization, away from the alleged harasser. Or alternatively, the organization paid the complainant to leave the organization. When harassment was actually substantiated, high-level offenders typically received a warning or training. The end goal in responding to the harassment claims was to keep the claim and settlement secret. All of this has changed with the coming of the Me Too movement. I have been at the forefront of this movement, helping organizations in the midst of the headline news crisis. I developed management techniques to ease internal stresses, strategically communicate internally and externally, and execute a legal strategy, all with an eye towards giving the affected organization the best chance of reaching their immediate and long-term goals. Starting in October 2017, women in Hollywood began coming forward with allegations of sexual harassment and assault perpetrated by the prominent film producer Harvey Weinstein. This spawned the emergence of the hashtag #MeToo, which became the vehicle through which other women shared their own personal experiences with harassment. The hashtag instantly went viral throughout the nation and worldwide. The hashtag was posted more than 12 million times on Facebook by 4.7 million users in just the first 24 hours of going live. As more and more women revealed their own sexual harassment experiences, many prominent men, not just in the entertainment world, but virtually in every other organization and sector of society, became the subject of Me Too allegations. Within this broader cultural shift in perspective, we have seen material changes in the workplace. In the post-Me Too era, we now have a rapid increase in claimants coming forward with allegations of sexual harassment in the workplace. This is a drastic shift from the underreporting of complaints we saw in the past, which was banded together with inadequate reporting channels, distrust in those reporting channels, and fear of retaliation for reporting. The Me Too movement has provided a platform to bolster these complaints and compel more individuals to come forward. News and opinions about bad conduct amplify quickly because of the far reach of social media. Employers must also grapple with a new level of public accountability, increased internal and external scrutiny, and a greater risk for reputational and business harm. So while the legal standard for what is sexual harassment and the defenses to such claims have not changed, the enforcement standard has definitely shifted. With that in mind, boards of directors are very concerned about the damage that can be done to an organization's brand in the face of a Me Too crisis. In the legislative space, many lawmakers see Me Too as a call to action to implement new laws and other measures to protect the victims of sexual harassment and assault, while at the same time removing sexual harassment from a cloak of secrecy. For example, there are bills pending in the House and Senate that would exclude sexual harassment claims from mandatory arbitration. Several states and municipalities already have passed similar statutes or regulations. Also, the Tax Cuts and Jobs Act, signed into law by President Trump in late 2017, includes a provision meant to discourage organizations from offering hush money to silence victims of sexual harassment. Section 162Q of the Act, now dubbed the, quote, Weinstein tax, close quote, will force organizations to determine whether to include a non-disclosure provision in a settlement agreement or forego deducting sexual harassment-related settlement amounts as an ordinary business expense on future tax returns. What are organizations doing in response to these changes? So in light of the new actions and attitudes brought about by the Me Too movement, what are organizations doing differently? Many are taking a more comprehensive approach on how to make, quote, zero tolerance, close quote, for sexual harassment move from policy to practice and a permanent reality. Responding to Me Too in a meaningful way requires a holistic approach to addressing workplace harassment, discrimination, and retaliation, and incorporating that approach into a larger commitment to diversity and inclusion. Organizations can't fire their way out of this problem. And changing corporate culture requires an organization to do more than publicize, update, or change its policies, reporting mechanisms, and training. Instead, employers must re-examine their organizational toolkits for addressing the cultural issues underlying these workplace problems. To change corporate culture to one of compliance, organizations need to engage in a campaign that is multifaceted. Such a campaign requires, one, evaluating corporate policy to align it with the culture that the organization hopes to achieve. Although a clear, comprehensive sexual harassment policy is an essential component in preventing harassment, any policy's effectiveness is ultimately a function of the cultural norms that leaders foster in their organizations, as will be discussed more in my next point. Organizations should also reevaluate their reporting mechanisms to determine their effectiveness and consider implementing additional measures like a phone app for employees to make complaints. Enforcement and accountability of these policies at all levels of the organization are key. Second, the campaign requires setting the tone from the top. The Me Too movement has presented a unique opportunity for leadership to set the tone in rebooting corporate culture. The board of directors, the C-suite, and other top leaders have a highly influential role in shaping and defining the culture throughout an organization. Third, the campaign requires hiring and promoting to enrich the workplace with diverse talent. Leadership should encourage managers to interview a diverse bench of candidates for each open role at the organization. Fourth, organizations need to enhance training to explicitly convey what is expected and required of employees. The focus should be on comprehension of the policies instead of mere legal compliance. Employers should also consider incorporating other topics, such as workplace civility, implicit bias, and bystander intervention in their trainings. Fifth, in addition, organizations must keep a handle on significant power imbalances within an organization. What many sexual harassment scenarios have in common is that the harasser wields some power over the victim. And finally, employers must act quickly and appropriately. Failing to acknowledge and punish sexual harassment and misconduct can convey a very direct message to employees that the behavior is acceptable and that the reporting of such behavior will not end it. Instead, the message that an employer should be sending is that everyone is valued and respected, and there is demonstrated commitment to diversity, inclusion, respect, and safety. Going forward, be particularly sure to stay abreast of the law and the news in the Me Too context. Along these lines, we will highlight some new and emerging issues to keep on your radar. First, shareholder lawsuits. The Me Too movement could trigger a wave of investor actions. To illustrate, Wynn Resorts Board and former CEO were hit with a shareholder derivative suit after the stock fell 20% when sexual harassment allegations against the CEO went public in early 2018. The suit claimed that the organization and its board of directors breached their fiduciary duties by sweeping accounts of Wynn's misconduct under the rug for decades. It is plausible that similar claims of breach of fiduciary duty could surface in the aftermath of Me Too. Second, there may also be changes to insurance. Carriers offering EPL insurance are now demanding that organizations institute or update anti-harassment policies and procedures, and are also making sure that anti-harassment training actually takes place. Third, we also expect an uptick in gender pay inequity claims. Me Too has pushed forward the focus on gender pay gap. In a recent survey, 48% of organizations say they are reviewing their pay policies with an eye toward closing the gender pay gap. Lastly, look out for the EEOC's new sexual harassment guidance, which is currently awaiting approval from the Office of Management and Budget. This new guidance will supersede several previously issued EEOC documents on harassment from the 1990s.
A crisis can arise in many contexts: Me Too allegations, environmental incidents, product failures, certain kinds of government investigations, a governance challenge, and data breaches, just to name a few. These are all crisis moments for organizations. But what exactly is a crisis? A crisis can take a few forms. An emergency or catastrophic event that happens without warning, that is often public and sensitive in nature. The classic examples are an oil spill like Deepwater Horizon, or a data breach of sensitive consumer information. A crisis may also take the form of an evolving issue. In these situations, the government, the plaintiff, or the whistleblower identifies a potential issue that has some public or media appeal to it. These types of crises may start relatively narrow, but then expand into multiple dimensions. And then the third type of crisis is one that may be avoided through foresight or containment. Generally, these are the slowly evolving issues we just talked about, where steps can be taken to minimize the crisis. But regardless of the type, one thing that all crises have in common is they put pressure on the entirety of the organization and require rapid, coordinated action that addresses short-term problems without affecting long-term prospects for the organization. It likely comes as no surprise to you that a true crisis involves multiple dimensions. In some crises, like Deepwater Horizon, for example, an organization may experience all of these dimensions in play. But in other crises, you don't see them all, but you see many of them. Often, you'll start with a government investigation. If that becomes public, you then may see congressional hearings or the state attorney general coming into play. And this, and for other reasons, there needs to be careful coordination with the organization's accounting firms and insurers. Perhaps the most vexing aspects of a crisis concern external communications. Everyone wants fast answers. Shareholders, regulators, customers, the media, and employees, just to name a few. The pressure is even greater in this era of social media and 24-hour news. In many, if not most crises, the organization will be pressed for answers, including the cause of the crisis and whether any ongoing harm has ended. Often these questions and complicated answers are not available with 100% certainty at the beginning of a crisis. But 100% accuracy is crucial to credibility and critical over the long haul. Often this may mean that the organization can address what it's doing about addressing the crisis, but must stay away from matters that are still not fully known. And managing the flow of internal information with an eye towards discovery in the inevitable litigation is critical. These are all reasons why we recommend putting in place a crisis management plan that considers the different facets and dimensions of a crisis in advance. You want to plan and consider when there is time to do so, rather than in the vortex of the crisis. Now, while we may be unable to anticipate all crises that an organization may face in the future, what you can do is to put together a crisis management plan. And having that plan in place alleviates some of the stress on the organization's decision makers during those first few chaotic but crucial hours and days of a crisis. Now, as an initial matter, we would recommend designating one of your outside firms as your legal crisis manager. You should draft the crisis management plan in conjunction with that legal crisis manager. The crisis management plan, then, has at least 3 elements. First, anticipate possible crises that your organization could face in the future. Consider your industry and crises that your peers have faced. Look at trends in government investigations, whistleblower lawsuits, and class actions. Evaluate the security of consumer or other third-party data you hold. And then second, pre-plan. Outline immediate response steps. That's critical. Third, identify the key members of your core crisis management team and your communication team. Describe their roles and decide what authority they have. Doing this planning in advance will streamline decision-making in the heat of the crisis. You can then focus on substance, not process. In addition, you should provide authority to individuals on your crisis management team to, number 1, direct resources. 2, support any outside crisis managers like outside counsel and communications professionals. 3, control the organization's message to ensure a unified voice in a crisis. 4, communicate with government responders or investigators. And 5, make sure we know who's going to begin the difficult work of evidence collection and preservation. On this subject, evidence collection and preservation, it will be important to identify one person on your team who will be in charge of data collection and preservation and who has knowledge about IT structure and backup systems. This will be a big role. The person will be tasked with managing document review and retention and coordinating and preparing for personnel interviews. To get you started on who should be included on your crisis management team, you'll see next to me a list of potential key players on a crisis management team. You'll notice the list contemplates selecting roles for members of your organization from top to bottom. We recommend including on your crisis management team the CEO and relevant business unit leaders, general counsel, in-house counsel, and outside counsel as your crisis manager, someone in corporate communications, an outside communications consultant, someone from investor relations and government relations, the compliance director, someone from IT or record management, and someone from building or facility security. Your crisis management plan should have a section on communication strategy, and it may be helpful to identify an outside crisis communications team in advance. And as I noted, there is an inherent tension between the need to say something to your constituents without getting ahead of the facts and making a well-intentioned but erroneous statement. And on that, it's important to know that the Department of Justice has gone as far as threatening criminal action against organizations under the mail fraud and wire fraud statute for making statements following a relatively benign comment explaining the course of a crisis that later turned out to be incorrect. It is therefore critical to strike a balance between providing important information to the organization's constituents while also ensuring that any communications are unquestionably accurate. As you are considering when to communicate, how to communicate, and what to include in your communications, you must be cognizant of future litigation and the potential for discovery of internal communications. Consider that every press release may end up as a potential exhibit at a deposition or a trial. And on the substance of your communications, there are generally 4 different communications approaches, and your crisis management plan should lay out different scenarios and the applicability of the following responses. A first approach is full disclosure and immediate acceptance of responsibility. A good example of this communication and response approach is Johnson & Johnson's approach in 1982, after it learned that several people had died after taking cyanide-laced capsules of extra-strength Tylenol. The organization immediately admitted fault and recalled 31 million bottles of Tylenol and offered a free replacement of regular-strength Tylenol. The second communication approach is limited disclosure with limited and/or rolling acceptance of responsibility. An example of this approach is the Exxon Valdez oil spill, where Exxon's chairman did not comment on the oil spill for nearly a week, but ultimately apologized for the spill while not accepting responsibility. An example of this approach from the Me Too movement is Senator Al Franken, who resigned in the face of accusations of sexual harassment, but in doing so, neither apologized nor accepted responsibility. The third communication approach is denial, which may very well be the right answer in some circumstances, but could also look to the public as a cover-up. For example, when Martha Stewart was accused of insider trading, she denied all accusations and held fast to her claim of innocence. And then the fourth is to take responsibility for addressing the crisis, without accepting responsibility for its cause. In looking at these options, it's important to know there is no one-size-fits-all. And if accepting responsibility has limited repercussions or puts tight limits on liability, that may well be the right approach. On the other hand, there may be circumstances where statements accepting public responsibility carry with them serious civil or criminal ramifications. And in those cases, it may make sense to express commitments towards eliminating future harm without accepting responsibility. Your crisis management plan should cover your internal procedures for managing the creation, retention, and content of written communications. Assisting you in this process should be the outside law firm which you have designated as your crisis manager, and your crisis manager can then set guidelines for communications with third parties, like a communications firm or PR firm, and can assist you in structuring your relationships with these third parties in such a way as to enhance privilege protection. In this regard, one of the least appreciated risks in planning communication strategy is the inadvertent waiver of the attorney-client privilege and work product doctrines.
One of the best ways to stay ahead of Me Too crisis is to check the cultural climate. Now, more than ever, employees are evaluating their workplace culture, both in response to specific complaints and Me Too allegations, but also as a proactive and preventive measure. The goal in assessing the culture is to identify risk and develop concrete solutions that promote a positive, inclusive workplace, mitigate the possibility of litigation, and preserve the organization's brand and image. Culture assessments adapt to the particular organization and the nature of the issue being examined. A culture assessment may include work such as developing and reviewing policies related to anti-harassment, anti-discrimination, and diversity and inclusion programs, conducting analysis from multiple angles by using interviews, focus groups, surveys, and other analytical tools, providing recommendations on how to remediate potential problems, and assisting in effectively communicating policies and programs to chief executives, general counsels, senior management, boards of directors, employees, and the media.
Prepare or update a crisis management plan. That planning helps organizations consider the types of crises that may occur, outline the processes for stabilizing and containing crisis situations, develop blueprints for required communications and methods for distributing necessary information. Identify and train key personnel in crisis response, and create and put in place processes for gathering facts, managing data, and making key decisions. Advanced plans can greatly minimize the pressure on an organization and its management as it responds to an emergency, and that helps to mitigate potential liabilities and costs. Designate outside counsel to be your outside crisis manager and work with them. It's critical to get your crisis management plan in place. That concludes our discussion today, and we hope these are helpful tips in preventing and managing a crisis at your organization. Thank you.
Thanks for watching Lawdition. Continue watching programs that will challenge your thinking, while getting to know the best lawyers in every field as they share their insights, and all while satisfying your CLE requirements. When lawyers audition for new clients, everyone wins.